uh, one thing that I always explain when I talk about research methods and all that research is a matter of skill. That is something every researcher need to appreciate and understand. In the sense that uh, I can explain it by way of an example. So, say for example, if I give you a book, say on theories of swimming, you would scratch your head and say, how can I? Because you have just read about what swimming is all about, not learned swimming. Swimming is a matter of skill. So what happens? You are trying to, concretize a vague idea that is, uh, coming from the darkness. Please appreciate and understand it, that the screen of the human mind, it there are hundreds of ideas that pass through this screen every single minute, every single second, let me tell you. And it is by picking up some of these ideas and concretizing them, giving them a personality, or rather discovering the personality of that an idea. This is how one need to understand the idea of research. You pick up a particular point and then put it in such a format that can be explained to everybody. That is what we call discovering the personality of an idea. Having talked about these 2 points, as that research is a matter of skill, and that research is an attempt at identification and concretization of an idea in the mind, or discovering the personality of an idea. Another point that we need to understand and appreciate is qualitative and quantitative research. I'm not actually concentrating on these controversies at all. Rather, I am trying to approach the subject from a common researcher's perspective, so that the common researcher can be equipped with some understanding of the research process, and thereby he, develops a certain research skill as well. Friends, also appreciate and understand it, that methodologies of research are named and classified in different disciplines differently. So, say for example, in science subjects, generally it is the empirical methodology and its subcategories that are generally the mode of research. On the contrary, in social sciences, qualitative research is the dominant methodology that we follow. I'm not saying that empirical research doesn't happen in social sciences, but generally these ideas are identified. Empiricism, or what we generally, I would talk about it, quantitative research, is more of a matter of science studies, right? um, in this presentation, I am talking about quantitative and qualitative research, purely, as I said in the beginning, purely from legal perspective. So the controversies associated with it, I'm trying to avoid and concentrate on the skill set that is required and that is involved in quantitative and qualitative research that we employ in legal research or any social science research. Also understand it that law students will have to appreciate it properly, that we generally classify laws on the basis of their purpose. Substantive laws, procedural laws, Indian Penal Code, Contract Act, Company Law, Corporate Law, the kind of a purpose, family law, that it seeks to seeks to fulfill the purpose it seeks to fulfill. So research methodology is also required to be understood from that perspective. Therefore, when we talk about, say for example, qualitative research, look at its almost similar terms or subcategories: doctrinal work, theoretical work, library research, and research, library based research or problem based research, policy research or law reform research. They are all actually synonyms, or one could say subcategories of qualitative research, trying to do a particular trying to achieve a particular objective. As I said, just as we define law according to its objective, we also define and name research efforts differently for the purpose of, as to what kind of a objective they seek to achieve. So doctrinal research, theoretical research, or problem-based research, or policy reform research, or law reform research, they are intended to achieve a certain objective. Ultimate purpose is, of course, to develop a certain understanding, to reach a certain conclusion, which is useful knowledge for future researchers. Now, coming back to the qualitative and quantitative research. Quantitative research is all about numbers, which means the things that can be quantified. They can be, quantified in terms of they can, what phenomenon is it? For example, how much pollution is there? You try to quantify it. And this you do by way of obviously empirical methods. So how much pollution? Is it 300, 200, 500, whatever unit we use for that purpose. And every kind of a quantifiable, element is tried to be looked from the perspective of statistics, from the perspective of numbers. On the contrary, qualitative research is about nature of things to be investigated, human phenomenon, the variety of problems which cannot be quantified. If somebody asks you, "Aap kitne khush hain? How much happy are you?" You cannot quantitatively say this much happiness. Say 10 units of happiness or 20 units of happiness. It is not possible. This phenomenon is something which cannot be quantified. You can just talk about it in terms of quality. So quality of happiness can be talked about, right? But not quantity of happiness. So qualitative research precisely makes an effort to develop a certain theory for the purpose of, better appreciating and understanding a phenomenon. What makes a human happy? What makes a human healthy? Whether, forcing some people living in the polluted environment makes them happy or healthy or sad or ill or what. So this is something, a theory is sought to be developed. Quantitative is, basically, as I was saying, is adopted in, in natural sciences basically. And the key feature of this quantitative methodology is quantification or measurement of a phenomenon. And I've been explaining it. So I hope that this is, this is appreciated by all of us clearly. Now, this quantitative methods that we keep on talking about, even in social science research, is basically something that has emerged from the positivistic movement that we saw in law and behavioral sciences during 19th and basically in 20th century. In social sciences, these behavioral movement and all that is more of a 20th century phenomenon. But the positivistic tendencies in law and legal sciences we witnessed basically in 19th century, which found its full bloom in 20th century, so to say. Now, obviously, positivistic movement is not known to be that dominant a thing in the current or in the contemporary times. Talking about critical research, as I was trying to explain, is qualitative in nature, and it seeks to develop or elaborate a theory which seeks to provide a more useful understanding of a phenomenon, right? I just tried to explain it. Recognition of a fact. This qualitative research is basically recognition of a fact that law is not found, but law is reasoned out. Finding a law could be a matter of quantitative research kind of a thing. But qualitative research basically, is a recognition of the fact from legal perspective, of course. that law is not something which is found, but it is reasoned out. So therefore, reasoned by what? Human reason. So law students will appreciate and understand that everything in law is reasoned out, deduced from a deductive methods that we generally talk about, whereby we try to appreciate and understand a certain phenomenon, and try to figure out what is the kind of a rule that governs this particular phenomenon. So qualitative research is not only, which seeks to find what the correct law or relevant law is, relevant case material is, but it also seeks to make a statement of law which can be verified. On the basis of its research, qualitative research, it not only makes a statement of correct law, does not only identifies relevant case on the subject, but also makes a authentic statement of law which can be verifiable, which can be verified, by cross-checking it. Therefore, qualitative research from legal perspective is a process of selecting and weighing materials. How do we understand selecting and weighing materials? And, put them in what we call hierarchical process of authority. So say, for example, if I start collecting, say, legal materials, I would always find legislation, its interpretations, case materials, journals and articles on the subject. Then what exactly shall be the hierarchy of authority? Obviously, the word of the law as it is passed by the legislature is obviously stands at the top. The case material comes second, and authentic interpretation comes third, and then other things follow, a commentary by an author, and so forth. So this is the kind of a qualitative research in which lawyers and judges are trained, right? So lawyers and judges are trained in the process of finding the correct law and putting it in a certain hierarchy. So this is the legal rule. This is a supportive evidence. This is a persuasive element, and so forth. There can be 100 opinions about a certain legal phenomenon. So lawyers and judges are trained in this kind of a legal research. I shall try to explain it with the help of giving you real steps involved in this. So talking about the steps that are involved in qualitative research, it starts with formulation or identification of a certain problem. This identification basically leads to, once you identify a problem, then you try to identify a law related to it. Then you go beyond that and try to figure out some cases that are available on it. And then other relevant materials, what we call generally the literature review, which is involved in journals, articles, textbooks, commentaries, so forth. Now, this kind of the way this legal research that I'm talking about, one can refer to Halsbury's Law of England, or during last 15-20 years, we have seen, Halsbury's Law of India also coming up. Now, look at, sometimes if you find time, I'm requesting law students, just have a look at the way this Halsbury's Law of England is designed. How it puts the whole thing. It makes a certain proposition of law, and then it supports that proposition of law by first primary authority, I mean the authentic interpretation of that, then the legislation that is made on the subject, and then the case law on it. So this is the way the legal materials are actually researched, and this is done by way of a qualitative research. So the first step is identification of a problem. Then we move on to the legislation and cases, identify the relevant literature on the subject, and then make a proposition of law, and then supported by primary authority, legislation, etc., and then the case material. Some of these materials may be binding, some of them may be persuasive only, not necessarily binding. It might happen that a particular legal opinion could be there, which is very reasonable and maybe in accordance with the law, but the law may be capable of being interpreted differently as well. So what is the authority of this particular opinion? Suppose the opinion comes from a high court, say High Court of Delhi, and I am standing in the High Court of Lucknow. Say, for example, High Court Allahabad bench in Lucknow. Obviously, authority that is given by the High Court is more of a pervasive in nature. This is how the legal materials are, classified and hierarchized, as we generally call them. Now, case digest, law students know, like All India Reporter and Supreme Court Reporter, Supreme Court cases. These are some of the law reporters. I'm not sure, because these days the research on online research has become very common, and not many people go back to AIR, etc. In fact, the AIR kind of a research helps us in finding the right law and the cross references very fast and very easily as compared to the online materials. Though SEC Online obviously gives us a lot of new tools whereby we can look back, the cases that were there at one point of time, what kind of modifications have been made into them, which is not possible by way of, the hard copy research as we do in AIR, SCR, etc. SCR is obviously, kind of, this is a very authentic record of the Supreme Court opinions. But generally, being an official record, it runs 2 to 3 years late. So a case is like decided today, and it will report SCR probably 2 years later. So that actually reduces its importance and its relevance. But nevertheless, SCR is an official record of Supreme Court opinions. SEC, we know, is one of the most popular online databases these days, and also available in hard copy. There are other, online databases like Westlaw, etc., which also helps us in, identifying these research materials. For example, checking the status of the case and the kind of modifications that have been made in those cases later. Friends, finding the situation is not enough. So I know the X problem is there. Say, for example, the problem of divorce on irretrievable breakdown of marriage. So what do I go for? Suppose it's a divorce in a Hindu marriage, for example. So I go to Hindu Marriage Act for that purpose. Now, this doesn't help me thoroughly. Whether that particular law is, what is its, what is its impact in the contemporary phase? How, effectively it is available during current times? What is its currency? What I mean? Then how judiciary looks at it. So you go back to Section 13 of Hindu Marriage Act, and which provides grounds of divorce. And then you see, irretrievable breakdown. So from where does it come? So please understand and appreciate it that finding a legislation of the problem is not sufficient. Rather, context of the legislation in the contemporary phase, what was intended, so referring to the parliamentary debates and Lok Sabha publications, which gives us the context of that legislation, and then how it is appreciated and understood today will be, discovered with reference to the case materials, right? Now, selecting research questions, selection of relevant literature, in all these cases in qualitative research, the problem is always of the bias.